Hello, everyone, and a very warm welcome to our Client Care and Professional Standards CPD webinar. I'm really delighted to see so many of our clients and in-house colleagues joining us here today. We know that the environment which we all operate in is becoming ever more complex, with new legislation, increased regulatory oversight, and the constant need to balance compliance with commercial realities. And these CPD sessions are tailored specifically for our in-house counsel colleagues, and we hope that you find them both helpful and also that they support you in delivering on the expectations which your businesses place on their legal support functions. So our session today brings together our practice specialists across technology, financial services and regulation to share clear, practical guidance on managing emerging risks, while maintaining that vital commercial focus that your organizations depend on. First up, we'll have Brian McElligott, who will discuss the responsible and effective use of AI in legal practice. Our AI team are actively advising some of the largest developers and users of AI technology, so he has a unique perspective in this area. Then Frank Flanagan and Aaron Garavaglia will then review recent updates on sanctions and export control risk. Both are highly skilled in this nuanced area of law, which carries significant financial and reputational risk, especially at the moment in the current volatile geopolitical environment. Finally, then, Julie Austin will examine data privacy and security. So we hope that you'll come away with some practical ideas which you can apply immediately in your roles. Please feel free to send in your questions at any time through the Q&A box, and we'll cover them then together after the presentations. Our Director of Knowledge, Sinead Coonahan, will host the Q&A at the end of our session. Your CPD certificate will be available quickly once you've submitted our short webinar and business sentiment survey just at the end. So thank you again for joining us, and as ever, if you have any other more specific questions in any matter, you can also contact the relevant team directly, who'll be very happy to help you. I'll hand over now to our first speaker, Brian McElligott, to begin today's discussion on the use of AI in legal practice. Thank you.
Thanks very much, Will, and thanks everybody for your attention today. As Will is saying, I'm going to have a look at the use of AI in practice, and I'm going to bounce a little bit between a couple of topics and hopefully make it all quite practical for you. So if we could have the first slide there, please. I would say that for all of us right now, the key to understanding how to use AI correctly in practice is to understand not only the law, but also what people would call the governance aspects of using AI. So I'm broadly going to break out the next 15 or so slides into a little bit of an understanding of what the AI Act means and if any impact it has on us using the technology in our practice. If nothing else, it will also give you a little bit of an understanding for speaking knowledgeably to your own clients. And then we'll spend a little bit more time on the AI governance piece, which is really the more practical aspect of using the technology, understanding the benefits and also the risks of using it. So if we can pop on to the first slide, please. So the AI Act is a piece of law that was enacted last year and is gradually coming into force over a series of deadlines. And the first of those kicked off on the 2nd of February this year when banned AI, or the ban on banned AIs came into force. This triangle here in front of us is a digital depiction of the risk classifications of using AI systems under the AI Act. And it was produced specifically by the Commission to try to demonstrate in a visual manner what these risk categories look like. And it has two functions. One is to provide you with the understanding that there are 4 layers of risk or 4 categories of risk. And the other thing is to demonstrate that the volume of risk goes up as you come from the top of the pyramid down. The most risky uses are at the top, indicating that the Commission, expects that, the banned uses of AI will be few and far between. And at the very bottom of the pyramid, you will have the most amount of AI uses, which actually, bar one particular obligation, have no obligations other than that under the legislation. So broadly, what are we talking about here? We're talking about the use of AI technology being treated kind of like a product. And that's kind of the best way I can describe it to you. in that the AI Act itself is very much part of the infrastructure of EU AI safety law. So what it talks about is the uses of the technology being regulated and not the technology itself. And the simplest way I can explain that to you is to say that you could have a technology, let's say, that is really good at document scanning and pulling loads and loads of information out of documents, and it would have little or no regulation under the AI Act. But if those documents are mortgage documents, and if it does one more step, which is to decide whether the individuals in those mortgages should be granted or not granted, or remortgage, or better terms or updated terms, that's a credit scoring tool, and it is a high-risk AI system, which is the second one down from the top. And we'll talk a little bit more about those. That is just to emphasize the point to you that how you use the technology is actually how it's regulated. There are four main categories. There's banned AI at the top. There's high risk, which we'll speak a little bit more about. There's limited risk, which is AI chatbots to the greatest extent. And then at the bottom of the pyramid, you have all other AI systems, which, bar the concept of AI literacy, which we'll also come on to, are unregulated. So you can see that your understanding of the AI Act very much depends on what AI you have and how you use it. So if we go on to the next slide, please. I put up these 8 categories of high risk for 2 reasons. One, we're going to speak about one specifically. And the second one is that I want you all to be aware that the list exists, so you can speak to your clients about it. But also the list is pretty limited in the broader sense of the use of AI technology. If you have an AI system that does something in one of these categories, more than likely it's going to be classed as a high-risk AI system, which is essentially a highly regulated AI system, something slightly on a par with a medical device or kind of pharmaceuticals. That's sort of a structure anyway, maybe not to that massive standard. And the sort of systems we're talking about here are using AI to remotely identify people using biometric data, or categorize them from their biometric data. Use in critical infrastructure, which is things like water, gas, and electricity. So let's say use in the grid as a safety component. Use in education, which would be an example like the grade scoring we had during COVID in the lead certificate. Employment, we're going to talk a little bit more about. Essential services is the example I gave you at the outset, which is like credit scoring, loans, life and health assurance, and all of these sort of things where if someone was to be denied because of the system, there will be, an allegation of discrimination. It can be used in law enforcement, migration and border control, the administration of justice, and also tucked away in that administration of justice category is the use of it in elections and referenda. So any sort of use in those sectors automatically should have your ears pricked up in that it is a high-risk AI system, or more than likely a high-risk AI system, and it comes with a ton of compliance uplift. So if we can move to the next slide, please. I want to talk specifically about HR systems because in reality, maybe not now, but over the next couple of years, this is going to affect us all. By far the most common use of AI I see in practice with regards to giving advice and counseling clients is the HR space. Now, so I'm talking about large systems which are able to, scan CVs and make recommendations on the basis of CVs based on a job specification, or use once employees are in place with regard to monitoring terms, updates, and anything to do with how the employee is performing in their role. This is a high-risk AI system. And there's 2 ways to look at this. One is the perspective of the provider, or let's say the manufacturer or developer of the technology. They have a significant compliance lift to take on board if they want to get the system on the EU market after the 2nd of August next year. The second one to look at, though, is the one where we're all going to come into play, I think, in due course, which is the deployer or the user of a high-risk HR system. And we will all have obligations when we take on those systems, and a few of them are on the page there, on the slide there. So it's like using it in accordance with the provider's instructions, generally having someone on the payroll who understands the tech and can use it in accordance with instructions and monitor it and oversee it. There's some other obligations you'll see there also. But from our own perspective, it is a significantly less onerous set of obligations than the provider or the developer. It's entirely doable, but the most important point to note is that you do have to do something. You have to take a positive action in order to actually take this technology into your organization. And I may not feel it right now, but I do feel that, you know, this technology will become pervasive and we probably all will be using it at some point. One final point I'll make on this is what I will call the kind of enthusiastic engineer problem. We've seen a lot with our clients where they have a lot of access to engineers, developers, and, you know, low cost, very powerful AI technology. And what they've been doing is, you know, chatting internally in the organization and coming up with amazing ideas to use the tech. And some of these ideas are for, you know, scanning CVs and, you know, trying to make the HR departments an easier life for them. But in the process, what they're doing is they're becoming providers of high-risk AI systems, because the use of the technology internally in your own organization, if you are the developer, even if it's only in your own organization, leads you to be a provider and take on that huge compliance lift. So it's more of a warning to you for your clients than you yourselves. Could I have the next slide, please? I'm not going to dwell on this. The penalties under the AI Act are very significant. They are higher than both the GDPR and the DSA. You can see the numbers on the screen there yourselves. They will kick in from the 2nd of August 2026. So we already have the ban on AI came in on on banned AI came in on the 2nd of February this year, as did the rules on AI literacy, but they currently cannot be enforced, even though some make arguments that it could be under private actions. But you can see that the fines are quite significant, and we should all take note is the key takeaway there. Next slide, please. So that's kind of the AI Act piece done, or kind of a whistle-stop tour of it for you, which is, you know, beware that the way you use the technology can lead to a classification, which can be a significant compliance uplift for you, and specifically be aware of the HR use, because I do feel it's going to come across all of our desks at some point. On to the second part now, which is the AI governance piece, or practically, how do we use AI internally in our firms, and what does that look like, and what do we need to be wary of? I put up on the screen here a whole bunch of words in a Venn diagram which all cross over with each other. I do this in order to convey what you probably see on things like LinkedIn, which is the market messaging around the use of AI, which is incredibly confusing in my opinion. You have people speaking to AI governance, AI ethics, responsible AI, safe AI, secure AI. Underpinning all of that, the two most important pieces of legislation will be the GDPR and the AI Act. But trying to get through this mass of messaging coming at you to try to understand, what do I really, really need to know about using the basics of AI in my organization, I find incredibly challenging, especially if you're someone who doesn't have a lot of knowledge of the area. So I'm going to try to give you a couple of basic pointers over the next few slides to see if we can get across the message that it is possible to use it, but you do need to be quite wary of how you use it and what you use. So if we have the next slide, please. The trigger for all of this market messaging, and why you'll see so many consultants in the area, is the advent of Gen AI, which kicked off around November 2022, but really took off through the course of 2023. When I say Gen AI, I mean something where you can interact with it and it is generating the answer to your responses. And that can be in most likely text format, but it can also be in images and video, as these machines become so much more sophisticated and also so quickly. They're advancing at an incredible pace. When I'm talking about Gen AI, I'm not just talking about ChatGPT, which is probably the most common one people are aware of, but I'm also thinking about things like Anthropic's Claude. I'm also thinking about Microsoft Copilot, which is actually the ChatGPT engine in the background. And also Teams. Don't forget about Teams, which is using things like recording in the context of meetings and transcription services, which we all need to be very wary of also, particularly in relation to things like confidentiality and privilege. So on that point, if we could move on to the next slide, please. There are a whole bunch of known legal risks with using this technology. And again, driving the point home, when I say this technology, I mean Gen AI in particular. And it's why we're all having these conversations and going on so many of these webinars at the moment. The main problem is the following. It's about a data processing issue. When I converse with a chatbot on any of the ones I've mentioned on the last slide, or many of the others, so many other of them at the moment, I'm essentially handing over the information I'm giving it, allowing it to process it and give me an answer back. But you have to ask yourself, the question is, where is that information going? And in most cases, you will be able to find out the answer, but the answer, regardless of where it's going, is it's out of your control necessarily, and you don't know whether it's crossing, the Atlantic out of the EU or not. So you're straight away running into things like, am I able to do this under GDPR? And if you're at home, doing up your shopping list or getting recommendations for holidays, that doesn't matter anything, to be quite honest. It's more in our role as lawyers that these things really come to the fore, and you have to think about them very, very carefully. So for instance, you will hear people saying, you should never put any of your client data into these AI engines. And this is the reason you should not put any client information, any sort of trade secrets, IP or anything like that in there, is that the minute you do so, there's a strong probability that you've breached any confidentiality that was in that information in the first place, because you've put it into a machine where you have no control over where the information is going. And if you destroy the confidentiality, you also probably have privacy GDPR issues because you didn't, I suppose, set out and think about them and solve for them before you did the act of putting the information into the machine. And a follow-on then is the possibility that if you're breaching confidentiality, you may be destroying privilege to the extent that that's an issue with the particular information. So you can see that the act of putting a few paragraphs of text from a letter or from pleadings or an email with a client could lead to significant consequences right out the door. So you have to be very careful about how you use these machines. It doesn't mean you can't use them. It's just you need to be very careful about how you do use them. The same sort of logic applies to things like trade secrets and intellectual property, which very much depend on things like confidentiality, particularly in the space of inventions, seeking maybe patent rights, where if you disclose them, you're disclosing or you're destroying the novelty potentially, or more to the point, destroying your client's novelty, which is an even more serious issue for you and your professional indemnity insurance. They're the kind of, let's say, the primary concerns, and that they stem from the loss of control, essentially. And I would hope that they're all quite obvious and clear. There are a couple of other concerns with the use of the technology, and you'll read about these in the newspapers, and particularly in the interactions of AI and the courts. And this is the issue of reliability or hallucinations. Put very simply, the machines are primed to give you an answer. They always want to give you an answer. And sometimes in the context of giving you the answer, they may not have the one or a reliable resource for it, and they may make up the answer, or they may make up part of the answer. It's because they're compelled to give you the answer. It's a part of how they're set up. So inherently, there is a potential problem with the reliability of what comes out of them. Now, having said that, the difference between the reliability issues at the beginning of 2023 and now is significant. Things are changing, they are getting better, but the issue has not gone away. So it's like a mental note to everybody when you're using it. The reason you have to check the outputs is because this is a known issue with the technology. When the technology gets better, as it does, and personally speaking, I've seen a remarkable update and change in it over the last 6 months, where some of these AI systems are incredibly compelling with their answers. They lead to other sorts of issues with using them, which is an over-reliance or let's just say, for instance, an over-reliance or a confidence in ourselves in using them. Because it does take a significant amount of skill to use these machines properly, and in a manner that will produce good outcomes and good results. The trouble with getting very good at it and getting very good answers back on a consistent basis is it leads you to the kind of false feeling of being able to rely on the outcomes, and it's kind of a jolt when you maybe will put something down on paper that when you really think about it and read it, you see that there could be an issue there. So it's related to that kind of reliability hallucination piece, is that you can get led into a false sense of security if you become quite good at using them and the machine answers are quite good. So that's kind of a summary of the key risks. If we could go on to the next slide. There's another layer I think merits a slide, and it's a bit of a nuance on the data flow issue. And I think everybody on this call really does need to be aware of this. And this is all about the type of AI you're using, or the license you have to use, and how, as you become more bespoke with some of these rights, you can start to use the technology in practice in a more free and open manner. So the first thing is free Gen AI. And when I say free Gen AI, I mean I open up an internet browser, I type ChatGPT into Google, up comes ChatGPT, and I start using it, let's say even without a login. That is kind of, I would say, the Wild West of putting information in there. You have to be incredibly careful about what you're doing. The next step up from that will be like an enterprise license or like a company-wide license, where you're getting like a discount and certain assurances with regard to, let's say, the company not training on your chats or your prompts with the machine. Legally speaking, there's very little difference between that enterprise Gen AI and the free AI, because again, you don't have control over where the chats are going and where they're being housed. And again, I would exercise just as much caution as I would do with the free Gen AI. The next two below are variations of each other, private Gen AI and bespoke. When I mean private Gen AI, I'm not talking about I suppose a kind of a sort of a private browsing nature. I'm talking about where the data is going and where it's being accessed and who can access it and where it's being stored. So what I'm really talking about here is the equivalent of how you might be using something like iManage or a document writing software in your practice, which allows you to be confident that everything is locked down and confidential. So it might look like something like a private tenant in a cloud space, or some form of a lockdown box in the cloud, where you can be absolutely confident that if you're typing entries that go in, they're not going anywhere to train or for trust and safety issues in the background. They're completely locked and they cannot leave that environment. Then you have a strong level of confidence that you can start to be putting in information you wouldn't otherwise put into the free Gen AI or the enterprise Gen AI. Why would you do it? You do it because you can start to get better outcomes and better answers. There's also kind of a variation of this, or a flavor of this, which would be bespoke AI, where you're able to, again, take this private environment and bring a model into that environment and maybe even train it on your own documents. Now, this isn't going to be happening very often. It's something we're looking into ourselves, but it is going to be costly, but there will be great benefits, I expect, in the long run. So what's the kind of the key takeaway from this particular slide? It's be knowledgeable about what you're buying or using, and apply the risks I've put in the last slide appropriately to how you can use the technology. So, you know, if you just have an enterprise license, don't assume you have a kind of a locked, confidential cloud box to deal in. You probably don't, and you need to be very careful about how you're using it. So if we can move on to the next one. Here are a couple of cases up there. I'm not going to go through them all. I'm just going to mention, I guess, the kind of the concepts that's behind this. And you would have seen a lot of publicity in the papers over the last year or so, even longer, especially beginning in the US last year, where I think it was a case in New York where a lawyer in their submissions, there was a couple of lawyers in their submissions to the court, had a whole bunch of references and citations to case law embedded in their submissions, and the citations led to links which really didn't lead anywhere, or they led to false or made up cases, and they were caught. My own particular take on that one is that, you know, there's nothing kind of massively surprising there. I mean, everybody's got to read their submissions at the end of the day. So if you didn't read the links to which you were, you know, which were being generated by the engine, is kind of tough look, is kind of a silly thing to be doing in the first place anyway. But it brings to light that kind of hallucination piece, and how the really worst case scenario for being found out about hallucinations is before a court, because it's incredibly damaging to your reputation in the court and otherwise with your clients. So it's nothing different to that hallucination point I was making earlier. It's not a new risk. It's more that it's kind of the risk made writ large, and your kind of silliness brought to the fore. One of the cases up there was a recent Workplace Relations Commission case involving Ryanair, where it was Ryanair calling out a lay litigant on their use of AI in their submissions. And their lawyers, the Ryanair's lawyers, said that they thought that the submissions may have been generated with the assistance of artificial intelligence, and they had proved that 7 citations provided did not have the outcome indicated. In that case, excuse me, the adjudicator was not particularly concerned about whether AI had been used, but parties were obliged to ensure they prepared relevant and accurate submissions, which did not set out to mislead. In this case, though, the submissions were rife with citations that were not relevant, misquoted, and in many instances non-existent. Now, the claim was dismissed, but that the AI aspect of it, I think, just brings to the fore a particular issue that everyone on this webinar should be watching out for, and that is the use of AI by lay litigants. I actually see it a lot coming into claims that come into the firm here, where you can see lay litigants using very, very flowery Latin language and very long constitutional arguments, which are clearly drafted with the assistance of AI technology. It can be hard to call them out on it unless they're referring to, let's say, a citation or a case that doesn't exist. And the reason is as follows. You can't prove that something has been generated by AI. There are tools out there which claim to do it, and they do it with varying degrees of accuracy. The trouble is that those tools in most cases are kind of free tools up online, and the extent to which then you copy and paste text into them, you yourself are engaging in the issue of breaching confidentiality by taking court information and putting into a free online tool where you have no control over where the information is going. Now, maybe this is with public pleadings, you might be able to make an argument for it. But you can see how sometimes it would be difficult to call out a lay litigant in these scenarios, where you yourself might get yourself into trouble by trying to prove they used AI in the first place. It's one of those things which is tricky in that when you read it, your sense might be, oh, you know, straight away, I can call this out as AI because of the way it's written, but it's difficult to actually make out the claim. I think courts and judges, though, are becoming a lot more aware of it. And I know that there was some guidelines published just this week. I think it was either by the courts or the law library on the use of AI, and it was a very kind of pragmatic sort of guidelines along the lines of what I'm talking about here, about being pragmatic about using the technology. If we could move on to the next slide, please. I make this FOI point more to drive home what I've already been talking about, which is the degree to which you can get yourself into trouble by not being careful with the tools you use. This is a Guardian report from earlier on this year, where Jeremy Kyle, the secretary in charge of things like AI, had his chats with ChatGPT successfully FOI'd by journalists, and they found out that, he was communicating and asking the tool very interesting questions about how he should approach policy with regard to AI in the UK. I guess this is something that's more embarrassing than, something that's legally poor practice. But from the perspective of everybody on this webinar, note that maybe you have some clients that might need to be knowing things like this. We've certainly communicated it to our public clients that if they are using these tools, especially the public ones, and that they're freely accessible, that journalists might be able to get access to their chats. Go on to the next slide, please. So then a couple of very kind of hard and fast rules for using the tech. If it's a free tech or if it's just a standard corporate license or enterprise license, just do not put in any customer or client data. Very straightforward, just do not do it. What are they good at? They're really, really good at brainstorming and playing devil's advocate. So they're really good, even the free models, where you might be teasing out a legal point to help you challenge your thinking on something, where you could say, here is what I'm thinking of, here's my potential solution, give me 3 reasons why it's right and 3 reasons why it's wrong, and explain your justification. And it will go through all of that, and we'll go through it in quite an amount of detail. It's not the answer, it's more you challenging yourself and using the information to try to get you to a better position. You have to check and flag any of the outputs that you're using, especially internally and especially for more junior members of your team and implementing a policy to that extent. They have to flag when they're using it so everybody knows what's happening and how to ensure things aren't slipping through. And finally, the most important point and the most obvious point, I would think, is you should never, ever replace your professional judgment. You can use it for all the brainstorming and all the assistance with documents and drafting and suggestions you want. But at the end of the day, it's your name at the end of the advice or the email or the letter or the memo, and it's your reputation on the line. So please treat it as such, knowing all of the failings I've pointed out so far. Next slide, please. The one piece that we all have to pay attention to is Article 4 of the AI Act, which says that every single one of us who are using AI, and in most cases, I think that probably means ChatGPT or Microsoft Copilot, we must have in place AI literacy training, and this kicked in on the 2nd of February this year. AI literacy training is difficult to pin down, but as simply as I can possibly put it is you have to put training in place in your organization that reflects who is using the AI and what AI they're using. So to give you an example, if we're working in a law firm, something like we're talking about right now is probably akin to a very basic entry-level AI literacy training. If you are working in an environment where a lot more sophisticated AI is being used or perhaps being created or modified, the people who are doing that might need more tailored training to them. So you get the sense that it's a graduated sort of a type of training. The Commission has put up and dedicated a website to AI literacy training where you can see what organizations are doing and get a sense of what good looks like and get help from that. Next slide, please. A solution I give to lots of people starting out and looking to use the tech, use it safely and use it in a manner that they can stand over from a governance perspective, which is kind of coming full circle to where we began, is to say, okay, if I have one legal obligation, and that is I must comply with AI literacy. So explore what AI literacy means for your use of the technology. Ensure that you are complying with that legal obligation. I would be astounded if 2 outcomes from that assessment is not training on the one hand with regard to your staff, and on the other hand, putting in place policies to back up that training and any analysis you do with regard to how you are assessing that AI literacy in the first place. What we're recommending to most people to put in place is something called a justification document, where you essentially outline how you arrived at your conclusion for how you will complete your AI literacy, why it is sufficient, and how you ran it. And in that case, you also have good governance in that you have a document to justify what you've done. And I think we've just one more slide then, please. Yeah, so kind of your action points or your takeaways at a very, very basic level are: do some sort of an inventory as to what AI you're using. You'll be astounded how much you are using. Even, dictation on your phone has some element of AI in it. But really what you're looking at is a sort of AI that kind of brings something new. And in most cases, as I said, it's probably going to be Gen AI. And you look at, what are we using? What sort of a license do we have? Where is the data going? And then roll out some AI literacy training, compliance, and governance that is suitable to that. And let's say as a 101 or step one on your compliance AI governance, safe AI journey, I think that will be a very good start. And that's me. So what I'm going to do is I'm going to hand you over to my colleague, Frank Flanagan. Thank you very much.
Good afternoon. I'm a partner in the Commercial Litigation Department in Mason Hayes & Curran, and the reason I find myself dealing with sanctions is I've been dealing with sanctions and export control dating back to the very start of my career as an engineer back in the late 80s, and then through the transition with the Wassenaar Agreement, and I dealt with it in relation to cryptographic systems and high-speed processors at the time. And through the course of my career in Mason Hayes & Curran, I've been one of a cross-departmental team of people who dealt with these issues. Until recently, it's been at a relatively low level relating to things like explosives that are used for flares or for lifecraft in the oil industry. But the Russian invasion of Ukraine has turned that whole thing around and made it very much mainstream. Next slide, please. Okay, the reason we're talking about sanctions is as part of client management is that it carries real risk. There are companies that have been shut down because of sanctions breaches. There are CEOs that have been sent to jail because of sanctions breaches. It's also a very difficult area to get your head round because there are multiple different regimes that apply in Ireland. There are separate regimes relating to various countries. There are separate regimes relating to various types of risks. And also you may need to comply, depending on your contracts and on the goods you're dealing with US or UK sanctions. You're likely to have to deal with multiple regulators. The Central Bank of Ireland is responsible for financial sanctions. The Department of Enterprise, Tourism and Employment is responsible for trade sanctions. The Department of Foreign Affairs is responsible for some sanctions. It's probably not legally possible to comply with all regimes. I have seen companies that have put in place contracts that says they'll comply with all sanctions. And to take the most basic, it's almost certainly not possible for you to comply with Russian sanctions. Another interesting point is some of your staff may have obligations based on their citizenship. Sanctions tend to apply to people who are citizens of a country, and some of your goods may come with restrictions, for instance, aircraft parts. Next slide, please. Since the Russian invasion of Ukraine, there has been a lot of work on investigations and prosecutions in relation to sanctions breaches. To take a couple of examples, in the Netherlands, one individual has been jailed for 3 years for providing assistance to Russia in relation to the manufacture of integrated circuits. Another company that worked on the Kerch Bridge, which is the bridge from Russia to Crimea, was fined €120,000. It also had approximately €1 million confiscated as the proceeds of crime. In an ongoing case in Germany, just to illustrate the importance the courts are attaching to some of this, a company has exported approximately €800,000 worth of laboratory equipment. It's facing one of its officers is facing a jail sentence of between 5 years, which is what the prosecution is asking for, and 3 years, which is what the defence is asking for. Nobody appears to be suggesting that he should actually walk away without a jail term. There are also a couple of lower sentences being sought in those proceedings. Next slide, please. While the various sanctions regimes aren't completely uniform, they do tend to provide a defence, which is effectively if the person who breached the sanctions did not know and had no reasonable cause to suspect that their actions would infringe the sanctions, they are not subject to any liability. But to avail of this, and the EU has been very clear on this, you need to have carried out appropriate diligence. Very broadly, it's really akin to a more robust version of what you'd do for anti-money laundering. The next slide, please. If we step back and look at the sources of the sanctions in the first place, Ireland implements UN and EU sanctions. The reason why EU sanctions are needed at all is that Russia is a permanent member of the UN Security Council and has a veto on UN sanctions being put in place. So the EU has stepped in to fill the gap, and in parallel with EU sanctions, there are similar but not exactly the same sanctions implemented by a lot of Western regimes. So the UK sanctions, US sanctions, Australian sanctions as regards Russia are going to be very similar, but they don't all necessarily name the same people, the same companies, and there are slight differences between them. The one thing that eases things slightly is as the EU implements all of the UN sanctions, you shouldn't need to look at all at the UN sanctions themselves. You can confine yourself to the EU. Next slide, please. Just to differentiate sanctions and export control, Aaron is going to talk about export control. Export control is designed to restrict the movement of goods, technology and services leaving a country, targeted for reasons of national security, multilateral arms proliferation control, and domestic economic interests. So it's really about the movement of dual-use goods, military goods, or things leaving a country that your country actually really needs. Sanctions, on the other hand, are, per the EU, not punitive. They're designed to seek to bring about a change in the policy or conduct of those who are targeted, with a view to promoting the EU's common foreign and security policy. All of that said, there are really significant overlaps between sanctions and export controls. You'll find quite a lot of the same goods are subject to both regimes, and you need to consider both regimes. Next slide, please. There are a lot of urban myths or misunderstandings out there about sanctions. Just to dispel a few of them very quickly. Sanctions do not only apply to Russia. There are sanctions regimes that apply to Syria, North Korea, a large number of countries. Sanctions do not apply to all Russians and do not apply to everybody whose name ends in "ov." You can't simply refuse to do business with somebody of Russian descent who lives in Ireland. You probably shouldn't refuse to do business with somebody who's got a permanent resident permit in Europe. Sanctions don't only apply to exports, they apply to imports. You are not permitted to purchase goods, or they are subject to some exemptions and some limited quotas. You can't purchase goods, the export of which assists Russia economically. Sanctions also don't only apply to goods and services with a government or military use. In the Russian context, they apply to luxury goods, and that's a very wide class. We'll talk about it a little later. A lot of people's first approach to sanctions DD is to do an internet search and see if they can find something that suggests they shouldn't do business with somebody and then to refuse to do business with them. We had, in one instance, we spent a considerable amount of time persuading a non-EU bank that it was legitimate to process a large tax payment to an EU tax authority by a non-sanctioned subsidiary of a non-sanctioned Russian parent. Personally, my touchstone for a lot of this is generally the sanctions are not designed to stop the flow of money out of Russia, especially when it's clearly being paid to a Western government. And the real gotcha that needs careful attention as time moves on is sanctions also apply to Russian-controlled parts of Ukraine. As the war develops, which parts of Ukraine are controlled by Russia changes, and you need to pay really careful attention to this if exporting to Ukraine. Next slide, please. Okay, trying to make this simpler for everybody, the best place to start is the EU sanctions map. The EU has a sanctions map on the web. If you look at it, you'll see quite a lot of the world is actually highlighted. Immediately below that on the page are a list of countries and a list of certain other sanctions regimes relating to terrorism that aren't necessarily country specific. The list of countries down there is actually larger than appears on the map. It's worth going there as a first port of call and seeing if any regime applies to the country you're dealing with. Next slide, please. Okay, having said all of that, there are too many regimes for us to try and talk about in a short session. So I'm going to focus largely on Russia. Since the Russian invasion of Ukraine, we're now on the 19th package of sanctions against Russia. So this is developing very rapidly. The rest of the presentation is largely focused on Russia, but the same principles apply to most regimes, not necessarily all of the restrictions. You need to look at the whole thing on a country-by-country basis. There's two main instruments in regard to Russia. There's the trade sanctions regulation, and there's the financial sanctions or the asset freeze regulation. These get consolidated a short while after each new sanctions package appears. The only way you're going to make sense of reading them is to look at the latest consolidated version as your starting point, and then check that it actually reflects the latest package. And as I said, there's usually a few days lag on that. Next slide, please. Okay, if we look first at trade sanctions and physical products, you need to understand precisely what your organization is selling or buying. And by this I mean precisely. There are issues, for instance, the export of certain bentonite clays is restricted. The export of other kaolinitic clays is not restricted. So you actually need to identify the correct CM code, which is the customs export code for the product being shipped, or the product to which know-how or intellectual property you're proposing to export relates. You then need to think about the actual product itself beyond necessarily what you're selling it for. Does it have potentially multiple uses? There is a product called PETN, which is a vasodilator drug. It's also an explosive. It's actually the explosive that was in the pagers that the Israeli intelligence service sold to Hezbollah. Nitrocellulose, otherwise known as gun cotton or collodion, is also used as a propellant in weapons. It's also used as liquid skin and in compound W wart remover. So both of these substances, nitrocellulose and PETN, are controlled substances, but there are exceptions for medical use in the regulations, and you may need to look for a derogation, or you may need to carefully see if there's an exception that allows your particular trade. But equally, you need to understand that if you normally sell ingredients to somebody who makes compound W in Russia, you possibly can't sell them 10 tons when they formerly bought 100 kilos a year. And the other piece of this is, if the product or component of crowd control agents, meaning sort of tear gas or equivalents, guidance systems for missiles, or anything else that fits into that space, you need to look very, very carefully at how you're classifying it and whether you think you can avail of an exception and whether you might need to apply for a derogation. Next slide, please. If I take one example, tantalum capacitors are capacitors that are almost certainly in the PC you're using, or phone you're using to watch this. They're in every piece of electronics. The CN code for them is 8532.21. Now, the CN code for capacitors in general is 8532. So CN codes are, the first piece is sort of a chapter number that identifies things at a higher level, and the extra stuff added on at the end identifies them in more detail. This code features twice in annexes to the trade regulations. It features in Part 2 of Annex 7, which triggers 2 articles of the regulations. It features in Annex 40, which triggers Article 12G. And Article 12G requires you to have a no export to Russia clause in any contract with any purchaser of these goods unless they're in certain specified sort of whitelisted countries. Then on top of that, the shorter code 8532 features in Annex 23, which triggers the application of Article 3K, which is another element of the regulation. Next slide, please. So, looking at the basic prohibitions where goods fall into these lists, you are prohibited from selling, brokering the sale of, financing the sale of, providing technical assistance, services relating to, providing assistance in relation to manufacturing, assistance in relation to maintenance or assistance in relation to the use of, selling or licensing or transferring intellectual property rights, trade secrets, granting rights of access or reuse of any material or information protected by intellectual property rights, or constituting trade secrets relating to the relevant goods, directly or indirectly, to any natural or legal person, entity or body in Russia or for use in Russia. So you cannot sell these goods to a Russian person. You cannot help a Russian person to make these goods. You cannot sell the machinery to make these goods. And I've also just noted on this slide that the importation of goods that originate in Russia and generate significant revenue for Russia is also prohibited, subject to some time and quantity limitations. Next slide, please. There are also restrictions in the trade sanctions in relation to the provision of professional services. So it is prohibited to provide accounting, auditing, bookkeeping, tax consulting, business management consulting, public relations, architectural, engineering, or legal advisory services to the Russian government or any legal person established in Russia. Next slide, please. The really important piece here is that even if you are an in-house lawyer in a group of companies that has a Russian subsidiary, you may not provide legal advice to that group company without a derogation, and this means applying to the department for a derogation. It does not extend to the defence of legal proceedings, where there is a carve-out effectively for litigation. And this prohibition has been upheld by the General Court, where representative bodies of the French and Belgian lawyers challenged it on the basis that it interfered with the right of access to justice. So it is simply a no-no to provide legal advice to a Russian company. Next slide, please. Luxury goods is a very strange classification of goods. It's basically things that are going to bother the Russian elite. It includes saddlery, yachts, sailboards, caviar, alcoholic drink, actually surfboards, antiques, works of art, and car parts. So if you're running an online car parts distributor, you can't supply most of these to Russia. There's no logic to the list, so almost every business that exports needs to check its products against the list, which you can expect to change with every sanctions package. Next slide, please. The other major regulation is the asset freeze regulation. It's very clear that all funds and economic resources belonging to, held or controlled by any natural or legal person, entity or body listed in the annex are to be frozen. So this is why there are billions of euro frozen in various bank accounts across the EU. It also provides that no funds or economic resources shall be made available directly or indirectly for the benefit of natural or legal persons, entities or bodies listed in the annex. This actually means you cannot, for instance, sell them goods that they can resell at a profit. That is making an economic resource available to them. You cannot advance a loan to them. The consequence of this regulation is that you need to check the ultimate beneficial ownership of every company you deal with, in theory. But the sovereign judgment, which was granted in relation to data protection, has restricted access to the universal benefit ownership registers to basically be for the purposes of AML. So what you need to do is require disclosure of the beneficial ownership as a contractual prerequisite. Next slide, please. You also separately have a duty to try to prevent circumvention. The EU has published fairly detailed guidance on this. Essentially, it involves looking for strange transactions. If you're suddenly selling a large number of surfboards to a landlocked city, you've got an unusual transaction. If some regime that doesn't have good quality export control and sanctions in relation to Russia appears to be your best new customer, you've probably got a problem. Next slide, please. There are other Russian sanctions that we don't have time to address. They relate to the oil business, payments to or from certain Russian banks, the movement of traffic by certain Russian ships, using Russian transport companies. The bottom line on this is if you're going to continue to transact business with Russia, you need to ensure that you can legitimately get your goods to or from Russia and that you can actually get payment. Next slide, please. Derogations are available in relation to most of the sanctions provisions, and we have assisted a number of clients in getting derogations. Sanctions are not designed to do things like cut off the supply of drugs or medical equipment, and the department will engage with appropriate derogation applications. We've also obtained derogations for Irish employees in non-EU subsidiaries to provide services to Russian incorporated companies in the medical area. Irish sanctions apply to Irish people wherever they are in the world, so you need to be aware of Irish employees working in other jurisdictions. Equally, foreign sanctions often apply to employees. If they're on holidays in the US sanctions will apply. Equally, they apply if you've got an American employee. Aaron, who'll talk to you next, is a US citizen. Aaron could not be involved in the supply of goods to Cuba, but, we've also advised clients in relation to exemptions that don't require a derogation application. However, even their spare parts are likely to be an issue, and spare parts for their equipment would have been an issue. Next slide, please. US sanctions derive largely from executive orders. Now, we actually can't advise on them. I'm not a US lawyer, but you need to be aware of some of what they do. The Office of Foreign Asset Control has a very useful website. As I said, they apply to all US persons. The definition of US persons may change by various sanction regimes, and you need to check that. They may prevent payments in US dollars if an EU business considers specifying euro rather than US dollars, or at least as a contractually permitted alternative, if divergent US sanctions prevent or are likely to prevent the contract being performed. As I've said a moment ago, if you have US employees, they must comply. And the other final point there is you need to be aware of US re-export restrictions on aircraft. They tend to apply at a de minimis of about 10% of the aircraft value. So even if you're looking at a European aircraft, say an Airbus that happens to have American-made GE engines, the US export control regime applies. Next slide, please. US sanctions apply to all US persons as defined by the sanctions regime. Some of the regimes apply to EU subsidiaries of US companies. Some of them purport to apply to all businesses with a significant US nexus. The EU does not or did not like the extraterritoriality of that regime and introduced the blocking statute, which was intended to protect EU businesses from the effects of US sanctions. But then Bank Melli took Deutsche Telekom to court because Deutsche Telekom stopped dealing with it because of US sanctions, and Deutsche Telekom had a large business in the US. The EU determined that it was not allowed to terminate the contracts solely to comply with US sanctions that are subject to the blocking regulation. What this really means is if you think you're going to have an issue with US sanctions of this form, you need to structure your business so it's not an EU subsidiary that's going to deal with jurisdictions that the US is likely to have a problem with. So ideally, have a US subsidiary deal with Iran, Cuba, Syria, and Venezuela. Even if they're just going to say no on the basis of US sanctions, your EU subsidiary may not be able to refuse to do that, or may need to find other grounds on which to refuse to deal with them. Next slide, please. The US also imposes secondary sanctions. There is an Irish company that had shipped second-hand integrated circuit manufacturing equipment that ended up in Russia. The US imposed secondary sanctions. Its bank froze its accounts. Then all of the subsidiaries of US companies that it was purchasing equipment from could no longer deal with it, and it's now in liquidation. There's not necessarily a clear legal basis for what they've done. Perhaps the EU authorities or the Irish authorities should have prosecuted here, but the effect, because of the business it's in, is that it is out of business because of US sanctions. Next slide, please. Key takeaways from this. Carry out a sanctions risk assessment. You need a risk assessment irrespective of what you're selling. If you're selling coffee on the international market, you need a risk assessment, and you need to develop a sanctions policy that goes with it. Think about including a no Russia clause in all your sales contracts. At the moment, it's only required for certain types of goods. But if you're not exporting to Russia, there's no reason why you shouldn't include such a clause, and it covers you for quite a lot of things. You also probably want a warranty that the goods you're buying internationally didn't originate in Russia. Try to minimize your risk of conflicts between multiple sanctions regimes. As I said earlier, try to avoid dealing in US dollars. Try to avoid having an EU subsidiary dealing with Iran. You need to know the citizenship of your staff and don't ask them to do anything that's illegal under laws that apply to them. It's very rare somebody's going to have an entirely US staff in Ireland and be restricted completely. You need to ensure your employees are aware of and comply with relevant sanctions while they're abroad, even on holidays. You need to be alert for unusual transactions that may indicate an attempt at circumvention. And if there's one takeaway that is really, really critical. Please do not provide advice, legal advice, to a Russian subsidiary. At that, I'm going to hand over to Aaron, who's going to talk about the export control regime.
Thank you, Frank. Hi, everyone. Today, I'm going to talk to you about export controls. Now, as a roadmap of what we'll be discussing today, I'd like to highlight that first, we will briefly look at the definition of export controls. We'll then discuss dual-use items, what they are, and why they're significant to you. We'll also consider how to apply for an authorization. Frank had mentioned earlier that we've acted for several derogations as well. That's a similar process to what we'll be discussing on the export control side. And we'll also discuss recent changes that we've noticed with respect to enforcement patterns in Europe, especially in Ireland. We'll then conclude with a summary of the key points from today's lecture that I think are important to walk away here with from. But first, before we get into that, I'd like to share a recent experience that illustrates the changes that have occurred in export control. We've heard a lot about an increased risk environment, and I think this story is a good illustration of that. Recently, we had a client whose request for permission to export was paused, and the client was asked by the regulator to provide evidence of the strength and thoroughness of their trade compliance programs. This was due to a concern by the regulator that the items to be exported could be diverted to Russia. This was notwithstanding that the client didn't do any business in Russia or with any Russian parties, and the destination for the export was not located anywhere near Russia. Luckily, our client had a sophisticated trade compliance program, which we were able to articulate in our response to the regulator, and eventually they did receive the authorization and permission to export. However, this experience shows that export controls have changed in recent years, and now there's a greater deal of risk, and there's a higher overall risk mitigation strategy that should be incorporated. Now, going to the basics about what export controls are. In very simple terms, export controls are rules that restrict or control the movement of certain goods, technology, or know-how from one country or one jurisdiction to another country or another jurisdiction. Export control regulations don't necessarily restrict the transfer of every type of good, technology, or idea. Instead, those that are subject to export control regulations are generally referred to as controlled goods. While there are several categories of controlled goods, for today, we'll focus on the one that will be most likely relevant for you, since generally it is the most common category that you'll see. These are dual-use items. Now, before we get into dual-use items, I would like to highlight one other significant category that, again, we won't be discussing today, but just to briefly mention it, the other significant category of controlled goods would be military equipment that is located on the EU Common Military List. If you want to transfer the military equipment on the EU Common Military List, either from one member state of the EU to another member state of the EU, what I would call an intra-EU transfer, or from a member state in the EU to outside of the EU or an extra EU transfer, you would need an authorization. However, this is just to mention that there is another significant category, but for today's purposes, we'll be focusing on dual-use items. Next slide, please. Dual-use items are goods, software, and technology that can be used for both civilian and military purposes. To determine if you're dealing with a dual-use item, you should first look at the EU dual-use regulation and the various annexes that accompany it. These annexes list various dual-use items, which are categorized according to a unique classification system. Whether an item is considered a dual-use item should be determined by that item's classification. Generally, this would not be a legal determination. The business would best be situated to make this determination, as they would be the ones that are most familiar with the product. I do want to highlight the two most important annexes to the EU dual-use regulation, which are annexes 1 and 4. There's significant differences between the two, which we'll discuss briefly. In Annex 1, a screenshot of which you see here, the dual-use items listed in Annex 1 generally require an authorization to be exported from the EU, so for an extra EU export. However, they may generally be moved freely within the EU, so an intra-EU export would not require an authorization. There are two examples here. These are for educational purposes and should not be construed upon or relied on for legal advice, as this is just a consideration for EU law. It does not take into account additional national laws that may require. But as for helpful illustration, you'll see in the first example from a member state to a member state, from Germany to Poland, if it is an Annex 1 dual-use item, an authorization is not required. However, from Poland to the UAE, so an extra EU transfer, an authorization would be required. Next slide, please. This is in contrast to Annex 4. The dual-use items listed in Annex 4 are considered extra sensitive. For these, similar to what we had mentioned earlier with the EU Common Military List, you would need an authorization to for both extra EU exports and intra-EU exports. Now, it's important to note at this point that some dual-use items are not listed in an annex. These are items that a regulator believes may be used for certain restricted activities, such as activities concerning chemical, biological, or nuclear weapons, amongst others. To export these dual-use items, notwithstanding that they aren't listed in an annex, an authorization would still be required. Next slide, please. However, the query doesn't end there. Under EU law, if you are aware that the item to be exported is intended to be used in certain restricted activities, like the ones I just mentioned about nuclear, biological, chemical weapons, amongst others, and regardless of if that item is listed in an annex, you're required to pause the export, notify the regulator, and wait for further instructions. If you see on the screen here, under Article 4.2, the second bullet point, I want to emphasize the word aware. That's the standard for EU law. Some member states, however, including Ireland, have a different standard, and it's important to note the difference between the two. In Ireland, you must pause the export, notify the regulator, and wait for further instructions if you have grounds for suspecting, emphasizing on that term, you see the last bullet point there, grounds for suspecting that items will be used for anything concerning these restricted activities that I have discussed. The differences between the two can be significant, particularly in Ireland, where the consequences for failing to make a report can be a criminal offense, punishable by either a summary conviction or a conviction on indictment. If it is a summary conviction, you may be liable for a fine of up to €5,000 and/or up to 6 months imprisonment. If a conviction on indictment, you may be liable for a fine that would be the greater of either €10 million or 3 times the value of the dual-use items concerned, and/or up to 5 years imprisonment. Next slide, please. Now, shifting gears to talk about authorizations. If you have a dual-use item and want to export it, the next step is to apply for and obtain an authorization. To obtain an authorization, you must apply to the appropriate regulator in the relevant EU member state. Which member state is relevant depends on if you have an office in the EU, where the dual-use item to be exported is located, or from which member state it will be exported. There is no EU-wide body that grants authorizations. This is a power that's reserved to the member states. If Ireland is your relevant member state, then the Department of Enterprise is your appropriate regulator. In Ireland, the Department of Enterprise has broad discretion to refuse to award an authorization, including if it believes that an authorization would affect or be likely to affect the security or public order of the state, or it would be inconsistent with EU national security policy or human rights considerations. The department is required to provide a decision only as soon as may be after receipt of the application. So there's not a statutory law that says they must provide a decision within 3 months, 6 months, 9 months, as you may see in other statutory regimes. Due to these uncertainties, it's really crucial that you, as solicitors, have a solid relationship with your client, and they can come to trust you and rely on you, as navigating the process for obtaining an authorization can be unpredictable at times. Now, a regulator may award any of 4 types of authorizations, which are listed here at the bottom. I don't have time to go into detail concerning the details of each of them, except I will briefly explain that they are generally organized on a risk-sensitive basis. And what I mean by that is exports of certain low-risk dual-use items to countries or jurisdictions that are politically, economically, and militarily aligned with the EU can generally avail of an authorization that can be applied in bulk, which is authorization 1 here, the Union General Export Authorization. However, exports of other dual-use items to other third countries that maybe don't have quite that same relationship with the EU may require a more restrictive and onerous authorization process. When exporting dual-use items to a third country, exporters ought to be aware of potential notification requirements under the EU's framework for screening foreign direct investment regulation. In Ireland, the Department of Enterprise has the statutory power to prohibit certain transactions or otherwise impose conditions on them if, among other reasons, the department has reasonable grounds for believing that the transaction affects or would be likely to affect the security or public order of the state. Next slide, please. Now, as for the enforcement trends that we've noticed increased enforcement and inspection activities, particularly in Ireland. As we discussed earlier, Irish law is stricter than the EU minimum standard. In Ireland, as we said, it could be a criminal offense for you to export a dual-use item, including items that are not listed in an annex, if you have grounds to suspect that it may be used for certain purposes. This is particularly relevant if your business is considering exporting to new markets that are opening up, like Syria, or to any places that regulators have identified as of high risk for diversion to restricted countries like Russia. Notice what I said is that not for exporting to Russia itself, but to countries that regulators, including the Department of Enterprise or the European Commission, have considered to have such a close relationship with Russia that items shipped there have a reasonable risk of being diverted to Russia. In our experience, while the Department of Enterprise does generally work closely and proactively with industry, things have changed due to the risk level that has elevated within the past few years, and businesses ought to be prepared to expect vigorous enforcement. I'd like to share another story from recently. We recently had a client struggle to receive an authorization to export dual-use items to a foreign government that had been a frequent customer of theirs for over 20 plus years. This was due to the department's concerns that the items could be used in a nearby regional conflict. However, there's some caveats to this. This concern was notwithstanding that the client had a very long-standing relationship with this particular customer for 20 plus years, and any previous applications that this client submitted for an authorization to export to this customer, which were many, were always promptly approved by the department. In this case, instead, the client was asked to provide evidence of its relationship with the customer, and particularly to confirm if its sales team had personally met with relevant government officials and seen previous products installed and used in certain government facilities. Eventually, this client and the client that I mentioned at the beginning of my talk both received their authorizations. However, they needed outside counsel to help navigate this process. Given this volatility, it is important to manage your company's expectations. This is where the strong relationship between you, the solicitor, and your client comes in handy. The sales team should understand that authorizations are not guaranteed, and in many instances can take several months before they're approved. During this period, there may be a lot of back and forth between you and the business and the regulator and the department in response to queries, whether formal or informal, or requests for authorization or for information. Ultimately, there's only so much control we have over a decision by the department to approve or deny an authorization. That messaging should in turn be communicated to partners and customers. Finally, it's also important to ensure that your relevant sales agreements include appropriate contractual language, which clarifies that all sales are subject to an authorization. Next slide, please. There's 4 takeaways I'd like to leave you all with. The first is the initial question should be, are you dealing with a dual-use item? To answer that question, you should look at the EU dual-use regulation, as well as the annexes to it, But you also should keep in mind that there are dual use items that are not listed in an annex. So looking at the annexes and calling it a day if they're not on there is not simply enough for you to comply. Second, you should understand what responsibilities you have under EU law and to the extent that they differ member state law like in Ireland. Again, this is the difference between being aware and grounds for suspecting. That difference can be particularly substantial, especially in jurisdictions like Ireland, where the latter can carry a potential for a fine of up to 10 million euro and or up to 5 years imprisonment. Third, all authorizations are discretionary. You should not expect to receive one, even if you could have expected to previously receive one under different circumstances in the past. When that happens, regulators may now be more prone to asking follow-up questions, and you want your responses to be so thorough that not only do they satisfy the regulator's immediate questions, but they're so comprehensive that the regulator does not feel that follow-up questions would be necessary. Fourth, and finally, crucially, the risk environment has changed, and we're seeing more enforcement activities across Europe. As my colleague Frank mentioned earlier, there is a certain amount of marriage between export controls and sanctions, so they shouldn't be viewed independent of each other, but rather as a mixed bag. Next slide, please. If you'd like to read more about export controls, we encourage you to check out these websites and to contact us at Mason, Hayes & Curran. Thank you for listening. Now, I'd like to introduce my colleague, Julie, who will discuss data protection, regulatory enforcement, and priorities.
Thanks, Aaron, for that, and welcome everybody to the next session, which is data protection, regulatory enforcement, and recent trends. So my name is Julie Austin. I'm a partner in the data and technology team at Mason, Hayes & Curran. So next slide. So as in-house counsel, you'll be handling significant personal data, some of which is likely to be sensitive data. And as such, it's very important that you're aware of your obligations and your organization's obligations under GDPR. In this session, we're going to examine some of those obligations. We're going to focus on data subject to access requests and data breach reporting and security, as these are the areas that you're most likely to come across in practice. Now, the Law Society does have a very useful data protection guidance on its website, which outlines the other obligations that you have as a solicitor in your organisation, and I do recommend that you would look at that. Before jumping into those topics, I'm going to look firstly at some of the recent activity of the DPC. So next slide. And we're going to do that by reference to the most recent report that is available from the Data Protection Commission, which is the 2024 annual report. So in terms of enforcement actions taken by the DPC, you'll have seen from last year, total fines issued by the DPC is 652 million. And of those, 80% of those fines relate to decisions into processing carried out by LinkedIn and Meta. That's actually, a low enough level of fines. When we look back at 2023, the total fines issued were 1.2 billion, which was record-breaking. The DPC in 2024 issued 11 decisions. 8 of those decisions were focusing on tech companies, 2 in the public sector and 1 in the media. So the DPC is continuing its focus on the tech sector, which is unsurprising. There have been 115 amicable resolutions in 2024 and 8 enforcement notices taken, and most of those enforcement notices related to non-responses to DSARs. So moving to the next slide. In terms of complaints, the DPC received 32,000 contacts in 2024, and of those, 2,673 progressed to formal complaint handling. We expect a much higher number of complaints in 2025. We expect that the number of complaints are going to increase by about 20%. So the DPC will be very glad they have an extra commissioner appointed in October, and their budget has been increased by an additional 3 million. Of those complaints from 2024, the top 3 issues were DSARs, fair processing, and the right to erasure. So these are types of issues that you should look out for within your organization and your practices around these issues. Unsurprisingly, 1 in 3 complaints related to DSARs, which is similar figures to 2023. The DPC has said that most of these complaints stem from insufficient explanations given to data subjects in relation to the exemptions that are applied to DSAR requests. And we're going to look at that in a little bit more detail throughout the session. Next slide. In terms of data breach notifications, in 2024, there were 7,781 notifications received, and that was an 11% increase on previous years, which is no surprise. What is a surprise, however, from my perspective, is that only 5% of those notifications related to hacking. There's been a lot of coverage in the media in relation to cyber attacks. It's interesting to see that those cyber attacks aren't trickling down to notifications to the DPC, or at least it's certainly not. They're not taking up most of the DPC's time. On the other hand, most of the data breach notifications that are made to the DPC relate to human error type issues. So half of all data breaches that were reported in 2024 related to correspondence being sent to the wrong recipient. So these human nature type breaches are causing most of the issues, and it really demonstrates the need to ensure that there's proper training and policies in place in your organization. So moving to the next slide. I'm going to quickly go through some of the decisions that the DPC issued in 2024 and 2025. I won't go into any of these in great detail, but I think it's important to recognize the types of areas that the DPC is interested in pursuing investigation and inquiry action, as it demonstrates the types of areas that you within your own organization need to be cognizant of. So in 2025, we saw a fine issued against the Department of Social Protection in respect of its use of the public sector social security card. And this fine related to the department failing to have a lawful basis for the collection of biometric data and failing to provide sufficient transparency in relation to that processing. We also saw a very significant fine in relation to the transfer of EEA user data to China. This case involved TikTok. We also saw a fine in relation to LinkedIn's use of behavioral and targeted advertising. There was also a fine in relation to a data breach that was suffered by the City of Dublin Education and Training Board. Next slide. We then saw 2 decisions in relation to data breaches suffered by Meta. We saw a decision against Groupon relating to its access and erasure requests. And this really related to Groupon's practice of requesting IDs in order to verify the identity of the data subject before responding to an access and erasure request. We also saw a decision against Apple. This related to Apple's practice of retaining hashed values of email addresses following erasure requests being complied with. Next slide. Again, we have a decision against Airbnb in relation to their erasure requests, and similar to the Groupon decision, this looked at Airbnb's practice of requesting an ID in order to verify erasure requests. There was a decision then involving Irish News and Media, which looked at the freedom of expression exemption under GDPR. Sligo County Council also featured in November 2024, and in that particular case, the DPC was looking at the council's use of CCTV and automated number plate recognition systems. Finally, there was a decision involving Maynooth University looking at a data breach which it suffered in 2018, and we're going to look at that particular case in a little bit more detail towards the end of the slides. So you'll see from those kind of trends that the DPC is looking at data breaches. It's looking at the exercise of requests by data subjects and transfers of personal data outside of the EU. So they're some of the topical issues at the moment that the DPC is looking at. Next slide. So then looking at data subject access requests. So as I mentioned at the outset, 1 in 3 complaints to the DPC relate to DSARs. So if you're dealing with a DSAR within your organization, it's really important that you're familiar with your obligations and how to handle these requests. But you should also assume that it's going to be very likely that these types of requests will result in a complaint to the DPC. Therefore, you need to be in a position to demonstrate how you responded to the request and that you responded to the request in a reasonable manner. Over the course of the last year or two, what we're seeing in practice is that the DPC is focusing quite extensively on the exemptions that organizations are applying to access requests. And the DPC is asking extensive questions regarding the applications of these exemptions. So in terms of the obligation itself, the obligation is to respond within 30 days or 90 days where the request is complex. Some of the exemptions that we're seeing the DPC question in detail include the manifestly unfounded or excessive exemption, and the exemption where the rights and freedoms of other parties are adversely affected by providing information. In terms of the manifestly unfounded and excessive exemption, this allows organizations to refuse to act on a request where the request is manifestly unfounded or excessive. And a good example of that is where there are repetitive DSARs. It's a very high threshold to meet to rely on this request. And there is a little bit of a grey area as to whether organizations can rely on this particular exemption to refuse to provide access where there is a very large request for a large volume of data over a large number of years. The guidance from the European Data Protection Board and the DPC seems to be contradictory in this regard. So in terms of the European Data Protection Board guidance, the fact that it would take a controller a vast amount of time and energy and effort to provide the information or copy of the data cannot on its own render a request excessive. However, when you look at the DPC guidance, it says something different. In that guidance, it says that controllers are not obliged to conduct searches which go beyond what is reasonable in terms of time and money, taking into account the circumstances of the case. So you can see that conflict between the European Data Protection Board guidance and the DPC guidance. Happily, the DPC has recently announced that they're going to be issuing guidance on this particular exemption. So this will hopefully address any disparities going forward. The other exemption that we often see the DPC question in practice is the exemption under Article 15.4, which allows you to withhold personal data where the disclosure of that data would adversely affect the rights and freedoms of others. So this comes up quite frequently when you're dealing with mixed data sets. So where the requester's data is mixed with other third parties' data, such as, say, for example, their spouse or their child or their colleagues. And in this particular scenario, what often was the practice a number of years ago was that organizations used to automatically apply redactions on a blanket basis to all third-party data. And the DPC is taking issue with this approach over the last number of years. So in these scenarios, what the DPC expects is that you have to consider the third-party rights and consider whether those rights prevail over the rights of the requester. If they do, and only in those circumstances, can you redact or refuse to provide the information of those third parties to the requester. The DPC also expects that you can demonstrate that you carried out this balancing exercise whereby you considered the rights of the requester and also you considered the rights of the third party. And the DPC has in the last number of months, started to ask extensive questions about the balancing exercise that was conducted by organizations. and has asked to be given a copy of this balancing exercise. So that's something that you should bear in mind when you're dealing with data subject access requests. So in terms of a takeaway, next slide. So firstly, document how you carry out these searches when you're complying with the data subject access request. The DPC, if a complaint is made, will ask for the methodology that you used when searching for documents and going through those documents. Also document your reasons for withholding each document. So the DPC, again, in the last year, has started to include in requests for information from organizations a request that they complete schedules explaining on a document by document basis why documents were withheld, the particular statutory exemption that is being relied on, and why that exemption applies in that particular case. So similar to how you would complete an FOI exercise, try and keep a schedule on a document basis explaining why you're withholding a particular document by reference to the specific statutory exemption. Where you are redacting or withholding third-party data, make sure you have a balancing exercise carried out and document that exercise so it can be provided to the DPC on request. And then finally, and importantly, don't forget that under the Data Protection Act and under the GDPR, you are required when refusing a request, either in part or fully, to advise the requester that they can bring a complaint to the DPC or seek judicial remedy. This is something that the DPC issued a decision against Microsoft in November 2023, because in that particular case, Microsoft didn't advise the individual of their right to seek a judicial remedy in the response letter issued to the data subject. Next slide. I'm going to move on now to data breaches and obligations under GDPR. So everybody will be very familiar with your obligations under GDPR to notify data breaches. Briefly, I'll remind everyone on this session, there is an obligation to notify the relevant competent authority of data breaches where there is a risk to data subjects, and the obligation is to notify within 72 hours or without delay. There's also an obligation to notify data subjects without undue delay where the data breach is likely to result in a high risk. There's also an obligation under Article 32 to put in place appropriate technical and organisational measures to ensure an appropriate level of security in respect of your personal data that you process. There's also an obligation under Article 33 to maintain a breach register, and that breach register must contain not only reportable data breaches, but any data breaches that occur, whether or not they reach the reportable threshold. Finally, there's also an obligation on processors to notify the controller without undue delay of any data breach that occurs. We will have seen, I suppose, in the media, a lot of reference to cyber attacks. Cyber attacks aren't always necessarily personal data breaches, but they can often be personal data breaches. So in the next slide, I'm going to bring you through the threat landscape when it comes to cyber attacks. So in terms of the sectoral overview, interestingly, the most targeted sector is the public administration sector. In terms of the other sectors most targeted, they are transport, digital infrastructure, finance, and manufacturing, with essential entities representing 53.7% of the total number of recorded incidents. So if you are in a sector, who is listed on this slide as one of the most top sectors impacted, it's something that you might bring back to your team and make the team aware of. Just in terms of the source of this information, I should have said from the start that this information is coming from ENISA. It's the Threat Landscape Report, October 2025, and it analysed almost 5,000 incidents between July 2024 to June 2025. Next slide. In terms of tactics used by cyber attackers, unsurprisingly, phishing attacks are the most prominent form of attacks, with phishing accounting for 60% of incidents reported in the study. Next slide. In terms of the motivation for these attacks, I think you might be surprised to learn that hacktivism is responsible for a very large proportion of the attacks that are occurring in the EU at the moment. Ransomware attacks, on the other hand, which are generally financially motivated, are very much on the decrease according to these figures. They were down 11% on the previous reported period. Going to move on then and finish out this session by looking at a very important decision from Maynooth University. And this is a DPC decision that was issued in November 2024. And it's a really interesting decision because it involves a set of circumstances that could, happen to any organization. It involved a business email compromise. And in this particular case, there was 6 email accounts hacked in Maynooth University, including 1 email account of an employee who dealt with pension matters. And in this particular case, that allowed the threat actor to access the content of those email accounts. One of the email accounts in question contained significant personal data, so personal data of 653 data subjects. And the data included in that email account included things like PPS numbers, contact details, location data, and financial data. So quite significant data. And the threat actor, though, could also control these email accounts, which allowed the threat actor to implement a rule change on the accounts, which prevented the account owners from seeing emails that were being sent and received. This then allowed the threat actor to perpetrate a fraud by diverting a significant pension payment that an employee was induced to make to the bank account of the threat actor instead of the bank account of the intended recipient. This is the type of scenario actually that we deal with quite a bit in practice. I've dealt with a number of these business email compromise cases over the course of this year, which have resulted in significant financial loss to a number of our clients. So next slide. It's important to look at the timelines of what happened here. So in this particular case, the transaction occurred in September 2018. It was detected in October 2018, so the 10th of October. The university noticed the creation of the rules on the email account and reset the passwords for the email account on the 23rd of October. They then subsequently commissioned a third-party report into the incident, which they received on the 8th of November. The DPO then emailed the DPC on the 15th of November, and a formal data breach notification was subsequently filed with the DPC on the 19th of November. And we'll come back to those timelines in a little bit later when we look at the findings reached by the DPC. Going on to the next slide. So, as a part of this inquiry, Maynooth University gave strong evidence that they had very significant measures in place in relation to the security of their systems, and they had in place lots of the measures that you would typically expect to see in an organisation. I've included them in the slide for you, which I'm not going to dwell on at the moment. However, the DPC examined these measures in significant detail and decided that the measures were not sufficient. Next slide. Some of the deficiencies that were identified by the DPC included that several of the devices in question didn't have updates being made to them. There was a lack of rules regarding passwords to be expired after a set period of time, and there was no controls in place to prevent users automatically forwarding emails to external email addresses. So I suppose here what I would be saying is that it's very important that you have a very, very good understanding of the types of measures in place in relation to your security measures. Next slide. In terms of the findings that were made by the DPC in this particular case, the DPC issued a fine of €25,000 for failure to have appropriate security measures in place. They also issued a fine of €15,000 for failure to notify the DPC of the data breach within 72 hours. The DPC found that they should have been aware that there was a data breach at the latest by the 23rd of October. Therefore, the breach notification was delayed by 3 weeks, and a fine was introduced to be on foot of that. The DPC also issued a reprimand and also issued a corrective order. In terms of the corrective order, next slide. The DPC ordered the university to take certain steps, and I've set those out for you in the slide. Next slide. In terms of the key takeaways from this decision, what I would say is don't defer notifications to the DPC pending receipt of a third-party report, unless, of course, it's reasonable to do so. The DPC expects notifications to be made very promptly and will look very poorly upon delays in notification. Also, if you are using your email systems to process personal data, the DPC will expect, as it did in this case, that very thorough risk assessments are carried out on those email systems to ensure that there are proper security measures in place. And then finally, robust policies, procedures, training, and regular evaluation of security practices and processes are absolutely essential. I would absolutely take this decision and give a copy of it to your IT team. It provides actually a very useful checklist of the types of security controls that should be in place over your email systems. And it's certainly a decision that your IT teams should be very familiar with. So that brings me to the end of my session. So I'm going to hand over now to see if there's any questions on any of the topics that we've discussed today.
Thank you, Julie, and thanks to all of our speakers for sharing their insights today. There's been a lot of useful, thought-provoking ground covered, and we hope you'll find some of it relevant to your own work. As Will mentioned earlier, I am Sinead Coonan, Director of Knowledge at Mason Hayes & Curran. Our knowledge team works very closely with our lawyers, supporting them in delivering clear, effective advice and helping our clients to make informed decisions with confidence. In particular, we look ahead to what changes are on the horizon that might impact our clients' businesses. On that note, and turning to AI and some questions, Brian, what are the most popular AI tools in use in the legal sector, would you say?
Great question. Yeah. You know what? Up until about, say, 6-8 months ago, I would have said Harvey AI is one of the main ones. It has been around for a couple of years now and has significant backing in Silicon Valley and is being used by a lot of the big firms and including ourselves. But more recently, a competitor has come in called Legora, and they're quite good also. So those two, I would say, are the primary two tools in the area. When I say legal AI tools, what I mean is a dedicated kind of modified sort of a tool specifically for the AI, for the legal industry, and which allows you to use them with kind of live client documents, so long as you've set it up correctly yourself. And that is the bit that would distinguish it from the sort of free AI and the enterprise AI I was speaking about earlier. There's an element of, you're getting a boost from using that dedicated tech.
Thanks very much, Brian. That was very helpful. Now, a question for you, Frank. My company stopped doing business in Russia in 2022. We've noticed that some of our competitors have begun looking at resuming business in Russia and feel that we have to do so to remain competitive in our sector. Can we resume business in Russia?
Okay, good question. This really depends on what your business does, who you're dealing with, and your tolerance for reputational risk. If, for instance, you're selling vaccines or other medicines, the risks are likely very low. On the other hand, if you're selling electronic components, it's probably a very hard no. Equally, for quite a lot of luxury goods, it's likely to be a hard no. We would recommend engaging with the EU Sanctions Help Desk, who are there to provide advice, who will advise you on whether or not there is any sanctions risk in what you're doing. They may be slightly slow, and we would also recommend that you're prepared for much more frequent interactions with the regulators and press queries. I've spent a lot of time on the phone with PR people for clients dealing with press queries relating to perfectly legal activities. There's also practical risks to consider. How are you going to get paid? How are you going to get your goods in and out of Russia, in or out of Russia? And can your compliance programs be revised quickly in light of additional restrictions? We understand, for instance, from a recent Ukrainian press release that the 20th EU sanctions package is at a well-advanced stage of drafting. So this is going to continue and sanctions are going to tighten. So it's a business-specific issue.
Okay, thank you. Thanks for that, Frank. Aaron, this one is for you. My business has several authorizations pending with the department, and our customers have threatened to cancel their orders and go to our competitors. What can we do?
In our experience, unfortunately, the scenario that you just described has become more and more common, primarily due to heightened risk in trading environment, and perhaps also we can speculate pressure that is being put on regulators from the EU level, from the European Commission. In these scenarios, we generally advise clients to contact the department and inquire about the status of your authorizations. You shouldn't be afraid of reaching out to the department and making that type of inquiry. Simultaneously, within your own four walls, we recommend advising your sales team about the changed expectations and realities now concerning authorizations. As for your customers, we appreciate this is a difficult position to be in. One successful tactic that we've seen with clients is generally they would advise customers that unfortunately this situation is really largely divorced from our own hands. And if they were to source the parts or the product from one of our competitors, they would likely be faced with the same scenario, particularly dealing with an EU export control authority. And at least with this, by doing with this continuous order, the process has already started and is well underway. Discussions with the department can be stressful. They can also be business critical matters, particularly when you have authorizations pending for perhaps large orders and your sales team is facing a lot of pressure from customers and from their own leadership. In those particular cases, we have helped clients in those scenarios and led to successful outcomes. When there's something as business critical as an interaction with the Department of Enterprise is at risk, we really recommend seeking legal advice in those circumstances to help avoid unnecessary and unintended consequences.
Thanks for that, Aaron. Julie, this is one for you. Will there be any changes to breach reporting rules under the simplification package?
Yeah, it's a timely question. A draft of the simplification package was leaked this week. So within that draft that we've seen, there are some changes that may be made to the breach reporting regime under GDPR in particular. There's two kind of key changes that are being contemplated by that draft. One is that the deadline for reporting data breaches would be increased from 72 hours to 96 hours. A lot of people will be delighted with that additional time, particularly on a Friday night. The second change that they're contemplating is that the threshold for reporting to the Data Protection Commission and other competent authorities may change from where there's a risk to where there's a high risk. So at the moment, the notification to the DPC is only triggered where there is a risk, which is resulting in a significant number of notifications being made to regulators, often where it's not really necessary. So if the threshold for reporting is increased to high risk, that means that there will be fewer reports made under GDPR if these changes do go through. So they're the two changes that are currently anticipated by the leaked paper that has been published this week.
Thanks, Julie. Great to get those insights. Brian, we might come back to you for another question, please. Is use of AI for legal advice high risk?
Great question, and one that might instinctively feel correct, but actually the answer is no. And and this is specifically in relation to using it in legal practice to provide advice. The use of AI, let's say, by the judiciary in making decisions, and by or on behalf of the An Garda Síochána, it's a different question, and it could lead to a high-risk AI. But lawyers using it is not high risk, and what I expect is the logic behind this is that lawyers are trusted to use their own professional judgment, not to be using it for such uses in the first instance, because at the end of the day, they're ultimately liable for the advice they gave, and they cannot be trusting what comes out of the machines for all the reasons I put out earlier. But yeah, simply put, it's not a high risk use according to the AI Act.
Okay, interesting. Thank you. Frank, we might come back to you for another one. I've seen articles reporting that some payment service providers like Revolut have recently blocked Russian and Belarusian citizens in the EU from accessing their accounts on account of recent sanctions. My client is in a similar industry. What can you tell us about this, and what do we need to do?
Okay, this is a complicated question, and I probably can't get quite to the root of it. We're aware of media coverage about Revolut freezing some customer accounts, pending those customers providing updated copies of EU residency permits. And I would speculate that this was done in response to the 19 sanctions package, which expanded the previous restrictions, and it now includes restrictions on issuing payment instruments or acquiring payment transactions or payment initiation services. I strongly suspect this was done in coordination with their regulators, and I don't know if everybody is aware, the CEO of Revolut was a Russian citizen. I believe he's renounced his Russian citizenship, and I think there's probably a level of scrutiny applied to Revolut that may be in excess of what's applied to quite a lot of other businesses. The bottom line is, I think if you're looking at a similar situation, you need to look very carefully at the 19 sanctions package. You need to look at whether or not you have Russian customers with residence permits in the EU, whether you have Russian customers with expired residence permits in the EU, and then sit down and do a really careful legal analysis as to whether or not whether you can or should suspend transactions or go back to them looking for updated residence permits.
Thanks, Frank. So it's really not a straightforward answer anyway. So we might have time for one more question there. Julie, is there any update on when NIS2 will be transposed in Ireland? Do you know?
Yeah, we haven't seen the bill being published as of yet. So I think it's more likely than not that it's going to be Q1 of 2026. I think it would be very unlikely to have the bill transposed into law by the end of this year. So Q1 2026 is probably the most likely time frame.
So watch that space.
Yeah.
Thank you. Well, thanks for that. And I know we could probably spend another hour or two on questions, but if we haven't addressed your query today, please do contact the team to find out how we can help you. A final reminder that your CPD certificate will be available once you've completed a short webinar, or short survey, I should say, and the business sentiment survey at the end. Thanks once again to everyone that joined, and a reminder to check out our upcoming and recent webinars at mhc.ie/events. Thank you.